With the recent indictment of Donald J. Trump, a number of people, especially on the far right, have been throwing literally every defense they can find at this to see what might stick. Now, his defense has pivoted to, well, lots of former White House officials kept classified documents when they left, like Pence, Biden, Clinton, and Bush. This is actually addressed in the Trump indictment. Prosecutors point out that indeed presidents had often inadvertently, or maybe even deliberately, taken documents that they shouldn't have. But mistakes happen. The government has always assumed the best of intentions, and so long as they were given back promptly, the government never really saw a need to make a fuss about it. Well, what about the 33 million classified documents Obama took with him when he left office? Well, if there are documents you need, you can actually get permission from the government to have access to them once you're out of the White House, which Obama, in fact, did. The documents were stored in an SCI secure facility in Washington. This means that they were in a room with no windows, cell jamming, GPS jamming, and with monitors for electronic eavesdropping devices, cameras, and multiple key card and security checkpoints between the entrance and the final room where the documents could be viewed. They're stored in a literal vault, and everybody who tries to access them gets searched going in and out of the building. When Obama was granted access to the 33 million documents that he requested, they didn't simply give them to him. They moved them from an SCI secure facility in Washington to an SCI secure facility in Chicago so that he could access them there a lot easier. And control was always maintained by the government. He always had to go to a secure facility to view them, and because of this, the government could revoke his access at any time. They had detailed records of what he accessed and when, and all of the documents were kept secure, and probably most importantly, they were available to other government agents if they needed them. These are government records. They keep them not so that Jack Ryan can protect the United States and protect them from Russians and give them hope that maybe they can grab these documents and learn secrets. The documents exist because they are important records that the government actually needs. So while indeed the government did give him access to 33 million documents, he didn't actually get the physical documents. He wasn't allowed to take them home and just, say, store them in the shower. They were maintained in government secure facilities the entire time. What about Hillary Clinton, who maintained a private email server, which she used to illegally store classified information and then deleted 33,000 emails right after getting a subpoena, which explicitly told her to save all of them? Well, she did in fact have a private email server, which she kept and used for both personal emails and for business emails while she was Secretary of State. And this violated State Department procedure and presumably also violated 18 U.S. Code 1924 regarding the retention of classified documents and materials, the very same code that Trump now finds himself in hot water over. She claimed that she had asked former Secretary of State Colin Powell if he thought it was okay for her to do it. That he in fact said, sure, go ahead, why not, it'll be fine. In reality, she did ask him, and while he didn't say, no, don't do it, he certainly didn't think it was appropriate or a good idea. But to the shock of no one, she did it anyway and hired Platte River Networks, a respected top-tier IT company, to manage this server, which she kept in her home in Chappaqua, New York. Because security was important to her, she decided that she was not ever going to store any classified information on that server. And in a review of 60,000 emails, the initial findings were that, in fact, there were no classified documents on that server. But upon a closer review, it was determined that, in fact, 100 or so of her emails were, in fact, classified. However, none of them were marked classified, which is, in fact, why it wasn't until a second review that it was determined that they, in fact, had been classified when she had them on this server. Now, given the fact that they didn't have these markings and that, in fact, the classified material represented only about 0.1% of everything that was on that server, it stands to reason that she actually really was trying to keep classified documents off of it, and that it had simply been a mistake instead of deliberately violating security protocols. Now, you could argue that as Secretary of State, she should have known that they were classified, and certainly should have known better than to have a private server and take the risk in the first place. And you'd probably be right. But there are some very big differences between this and the allegations against Trump. First of all, the information actually did belong to her. The private server was a bad idea, but those emails were in fact directed at her. She was supposed to see them, and she was supposed to see and have the confidential information they contain. More importantly, she cooperated with investigators. When they asked to see her server, she turned all of the information over. She gave them as many interviews as they liked for as long as they liked, and she answered all of their questions. She didn't plead the fifth, she didn't defy court orders, and she didn't try to cover up what she was doing or even deny it. Indeed, Comey pointed out that while she had violated procedure, it wasn't clear they could prove she had violated the law. And as with past precedents, if someone had honestly tried to keep the information secure, worked in good faith with investigators to fix the problem, and if there was no real damage and certainly no criminal intent, Comey said that the government didn't usually prosecute. Okay, fine, but what about the emails? Well, in 2014, Hillary Clinton met with her staff, and there was a mutually agreed decision that they should lower the email retention period on her server to 60 days. This meant that emails older than 60 days would be deleted automatically by the server. These kinds of adjustments are common, and the meeting notes reflected that everyone agreed that it had been a good idea. Her chief of staff contacted Palat River Networks and asked them to change the retention period to 60 days. They replied that it would be done by the end of the business day. Palat River Networks then got in touch with one of their technicians, a man by the name of 𝐒𝐨𝐜𝐿, and instructed him to make the change immediately. Now, this was a Friday, and he knew they wouldn't let him go until it was done, but he also figured it wasn't really urgent, so he decided he would do it on Monday when he returned. So he emailed his bosses and said, "I've made the changes. I'm going home for the weekend. See you on Monday." One thing led to another, and come Monday, he forgot to do it. 4 months after this, Hillary was hit with a subpoena telling her to save all of her emails. She immediately notified PRN and told them to halt deleting emails and to save all of them, complying with that subpoena. However, when PRN notified 𝐒𝐚EDA that he was to save all of the emails, he had what he described in his sworn testimony as an, quote, "oh shit" moment, when he realized that he had never made the change to the 60-day retention period. This presented him with a problem, because if he followed through with the orders to keep all emails, it would be obvious that the retention period had never been set. He resolved, therefore, to delete all of the emails that were not consistent with the retention period as he had been instructed to set it. He then used a program called BleachBit to cover his tracks, delete all evidence of these emails, and then reported that he was saving the emails in compliance with the subpoena. Hillary Clinton, as it turns out, was rather surprised that she had called the security firm, told them to keep all of her emails, and they promptly deleted 33,000 of them. The company, too, was rather surprised, and the technician suddenly found himself the focus of a criminal investigation led by the head of the FBI. Now, Comey did what every serious investigator should do, what Jack Smith did in the Trump case, which is to doggedly chase every single element of this case, anything that had even a whiff of foul play. He got the original meeting notes on the change of the retention date, got the chief of staff emails asking for the change, the follow-up promise to do so by the end of the day, got the emails between the company and their technician, the technician back saying he had done it, and all of the records saying it was in fact never done, and the confirmation sent to the chief of staff, who then sent it to Hillary all 4 months before the subpoena ever came out. They got all of these emails, and on both sides of the conversations, because all emails actually have 2 copies, one on the sender's computer and one on the receiver's computer. All of these copies were investigated by the FBI, and the entire full weight of the Bureau was unable to find any evidence that any of them were not genuine, that this hadn't happened, that there had been tampering, or that any of this was fake in any way whatsoever. Meanwhile, everybody who was asked to speak before the FBI in this matter cooperated, with the exception of one person, the technician who pled the fifth. What's more, since there are 2 copies of every email that gets sent, Comey decided to track down all of the deleted emails and see how many he could find. He went to all of the people who communicated with Hillary Clinton and got her emails from their servers. Doing this, he was able to recover 95% of the missing emails and found that not a single one, not one, contained any incriminating evidence or any motive for her to illicitly delete these emails. Now, the only lead that Comey hadn't followed up was the technician, who was not cooperating, and he had two choices here. He could prosecute the technician, and there could be a trial, but he was aware it would look like the technician was a scapegoat. And it also would deny the ability to actually get the truth out of the technician. He would simply clam up, plead the fifth, and then lose any ability to get legitimate testimony from him. Or should he offer him immunity, at which point he would be able to compel him to testify and to talk about how and why he deleted the emails, and to see if maybe Hillary had contacted him and said, listen, I need a solid. By this point, he was already reasonably sure what the technician would say. There was no evidence any such communication had ever happened, and everything panned out as this was just a mistake. But he knew if he didn't get the testimony of this technician, his case would be picked apart for that glowing oversight. If he did get the testimony of this technician, the only way to do it would be to offer immunity, which would make it look like he was maybe getting a free pass and a reward for maybe having deliberately done something illicit. So it was a lose-lose, but he decided to err on the side of following every lead he possibly could. The technician was given complete immunity on his testimony on the condition that he spoke honestly about it. And this is an interesting condition. This is done often in criminal cases because you don't know what other people have testified to. And your friends may say, oh, don't worry, I didn't rat you out, but maybe they have. Maybe the FBI has evidence of a phone call or a note or this or that you don't know about. They don't tell you the evidence against you. The trial hasn't started. They don't have to. So they say, tell us the truth, and you will be immune from prosecution for these rather serious crimes. But if you lie to us even once, if you cover anything up, if you protect anybody, even yourself, not only does the immunity go away, but everything you've testified now can be used against you because you have violated the immunity agreement and otherwise spoke of your own accord to prosecutors about the crimes you've committed. Comey gave 𝐒𝐚EDA immunity and took his testimony, and the testimony was concurrent with the testimony of all of the other participants in the email scandal. Now, I get it. The witch queen of Chappaqua is unlikable, conniving, cynical, and an all-around person I am not a huge fan of. But even Machiavelli had evil henchmen, and even those henchmen would probably make mistakes. Mistakes are human, and they're made on all sides of the aisle by people good and bad. And it seems entirely plausible that this is exactly what it was, a mistake. And all of the evidence shows that it was a mistake. And while it seems convenient mistakes happen. And again, with not a single email ever recovered that shows a motive for her doing this, it's a convenient mistake to cover up nothing from what anyone can tell. At a minimum, there appears to be no evidence whatsoever that she did anything wrong in regards to the 33 million deleted emails. And since the courts work with evidence, not with intuition, not with your gut, and not with whether or not you like the person, and I think most people listening to this prefer it that way. We say that we don't want political witch hunts, that we don't want people to be prosecuted just because they're on the other side of the aisle or because you don't like them personally. Well, after the FBI finished its investigation, Congress launched its own and interviewed Comey, interviewed the people involved, and held public hearings, and was unable to find a single fault in Comey's report that would have changed the outcome of the conclusion. In the end, there was never any evidence that she had done anything wrong, and a lot of evidence that this was simply a technician who did something really stupid, but honestly kind of understandable if you were in his shoes. If a Republican Congress hell-bent on finding something couldn't find anything. It seems to me that it's probably about time we let it go. I don't think if they didn't find evidence then, you're going to find any evidence now. It's one of those things that's probably just a colossal waste of time to keep looking into. But if you are Donald Trump, you probably want people wasting their time investigating other scandals that look like maybe related instead of actually getting into the facts of his case. 6 days before he left the White House, the Government Records Administration knew that he had documents he shouldn't and reminded him to turn them over. On May 6th, 4 months after he left office, the government informed him that he still had a whole bunch of documents that weren't his, and he really had to return them. They belonged to the government. The government needed them, and he had no need for them anyway, aside from the fact that he was incapable of holding SCI secure documents. Now, Trump tried a litany of defenses, including that he didn't have them, or he couldn't find them, or he wasn't sure where they were, and yes, of course, he had them and he'd returned them. But it turns out that while he was saying that, he had been telling his lawyer that he wanted to keep these documents, and that he expected that he could either lie to the government or just hold on to them anyway, and at one point apparently even asked his lawyer to destroy the documents, saying that, well, Hillary Clinton's lawyer did this and he got away with it. In fact, if you're a lawyer, you can do it and you can't get in trouble, which is really crazy that Trump is giving legal advice to a lawyer saying that he can commit a federal offense and it'd be perfectly fine. The lawyer, by this point, had been documenting all of this because he was being asked repeatedly to do illegal things, and he was repeatedly telling Trump that he had to comply with the government's requests. By April, nearly a year after the government first asked him to return the documents, they finally went to a grand jury to force him to return them. There's this narrative that they wanted the documents back and they just burst into Mar-a-Lago and raided the place. They had been asking for a year. He had orchestrated a complex scheme of moving the documents right before they were looked for, in particular by his attorney, who he decided to hide documents from as well. He would move them from the secure room at Mar-a-Lago, which was basically a room with a padlock, and move them from there to the shower, to his personal bedroom, to whatever areas, and then literally moments after searches for the documents were complete, he would move those documents back. This is someone who is deliberately hiding this from the government, and it is very different than every one of the other cases that we've discussed. Trump isn't going to be convicted by Biden. He's not going to be convicted by the prosecutor. He's not going to be convicted by the judge. He's not going to be convicted by the press and all of the people that he says is out to get him. If he is convicted, he is going to be convicted by a jury of his peers in which he has a significant say in their selection. Now, I feel very strongly that he should be treated fairly and be treated like anyone else who is charged with a crime. But that doesn't just mean that he gets a jury of his peers and he has the right to remain silent and he has the right to counsel, but that also means that we go based on the evidence. And if the evidence says he did these things, it is unprecedented and it needs to be addressed.